Welcome back. This is the last part of the ongoing investigation. The one you've been watching, the 1 and 2 and 3 and 4. This is the 5th one. And you can see what has happened during the course of this investigative panel. 4 prison officers and 10 of them on the seat. But we have 4 of them, they put them on the stand to come and say what they know about the allegation put against them. Then we have 2 Efcc officers, a male and a female, even the female in hijab. They were there to defend the organization. So, and you can see the way the questioning was going. You can see elderly men. You can see the way they've been throwing questions to them and the way they've been rubbling and wobbling, not being able to answer their question directly. So, I mean, this last part will give you the insight into what happened with the EFCC or EFCC officers and the way they answered their own questions. So, I know this is not the end of the story, but we were expecting the time and date and day when they will call Bobrisky himself to come and take the stand, because it's not there now and everything centered on him. So he should be questioned openly, so that at least not cover up, and we will be able to know what happened, the details of what happened. Though there have been a little bit of light into what really went on behind the scene. But right now, you can see where it is now at this stage. So thank you for watching. This is Choki Table Media. Don't forget to like, share, and subscribe. And credit for all these videos that splitted into pieces goes to Symphony TV, or Symphony Media. So thanks so much for the videos. See you next time. Bye for now.
Let's have the man in charge of.
Do solemnly swear that the evidence I shall give to this committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Please, you have 10 minutes.
Honorable Chairman, all protocol duly observed. I, DCC Sikiru Kamaru Adekunle, took over the maximum custodial center on the 9th of June 2024 on transfer from male prison Ondo Shegede. I'm not the one that received Bobrisky Idris Okuneye on transfer from medium. It was received by a retired DCC whom I took over from, though he's alive. And I managed Idris Okuneye under my watch from the 9th of June till 5th of August, when I discharged him accordingly. The discharge warrant, the discharge certificate is here, submitted. The original warrant is here, submitted as well. And I took pain to gather all the receipt parts right away from the month of April, May, June, and July, because the record were intact. All these documents were submitted, sir.
Okay, Patrick.
This is not supposed to be your question. I should have handled it with your superior. Since you're here, now it seems a caricature of the Nigerian Correctional Service that there will be a press release suspending officers, and your superior steps up here or steps out here and says they have not been personally served, and so they are still in uniform. Is that how it works there?
Sir, this is a regimental service. If you are not very cautionary of the word you used, one might still be dead switch on it. Honestly, it is like everybody had on paper, on here, that myself and my colleague from Medium were suspended. But up to today, there is no letter to the effect.
Have you taken steps to verify if you're still in service or suspended from service as a dutiful officer?
As a dutiful officer, if somebody is on suspension that is adding such a custodial institution with immediate effect, there will be somebody to replace him. So far as nobody is there to take over from me, I should maintain the ground for the safety of the country.
So kindly confirm that the suspension was a farce.
Not yet reversed, but as it's on paper, I hope.
No, are you confirming that? Okay, I'll give my word now. Are you confirming to this parliament that the suspension was fake?
Okay, no, I didn't touch it. People were passing. The battery.
They need to on it. It's on permanent.
For final last order.
Huh? The mic is not working.
Aye, then you mention your name.
I, Alona Baba,
Do solemnly swear
do solemnly swear
that the evidence
that the evidence
I shall give
to
to this committee
this committee
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Help me, God.
God help me God. So, as the name implies, as the name implies, my name is Haliru Baba, MFR MNI. As the name implies, my name is Haliru Baba, MFR MNI, the Controller General of Nigeria Correctional Service. The presentation being made by the Controller of Corrections in Lagos State that Bobrisky has served his sentence is actually true. There is no time that Bobrisky spent a single day outside. On the second issue of suspension, the officers concerned were duly suspended by the board to pave way for investigation. That is where we are now. And the letters will come today because it was on Friday. The letters will come today from the board. That's all.
The prosecutor is here. Belukisu, yes, not Rotimi Oyedipo. So if the committee wants her to make a presentation, she's here, but not Rotimi Oyedipo. She was not the one. But I would like to also, yes, the prosecutor is here in court. Yes. Thank you.
Becky, please come.
The CCTV camera recording showing Mr. Idris in the correctional facility in that maximum within that duration. You have to prepare it and also tender it to us. When he arrived the facility and when he was discharged. Take note of that.
Mr. Chairman, sir. Mr. Chairman, can we...
Bilkisu Buhari, do solemnly swear that the evidence I shall give to this committee shall be the truth, the whole truth, and nothing but the truth. So help me God. Honorable Chairman, sir, and honorable members of the committee, standing on all existing protocol. Sir, the Special Duty Legal of the Lagos Directorate received the case file of Idris Okuneye, aka Bobrisky, on the 4th of April, 2024. After the receipt of the case file, my team sat down to come up with the case plan and proceed with the case. That in the course of carrying out the commission, in a bid to curb the mutilation and naira abuse, set up a special task force to look into this offense. And Bobrisky was apprehended in the course of that. Sir, in the case file, the statement of the ex-convict confessed inter alia that Bob Express is not registered with SCUMO, that is Special Control Unit Against Money Laundering, because I'm not aware of it. Ignorance of the law is not an excuse, which informed our decision to charge him for not rendering returns contrary to the Money Laundering Act, Section 6(1), and punishable under Section 19 of the same Act. However, on the 5th of April 2024, we moved a motion for the Honorable Court to hear the matter because it was a vacation matter, and we were granted leave to proceed with trial. Notwithstanding the unequivocal confession of the ex-convict, convicting the essential ingredients in counts 5 and 6 of the charge, and having indicated willingness to plead guilty to counts 1 and 4 of the charge, which has to do with mutilating of the naira currency, the prosecution in total fidelity and conduct its oath and strict adherence to professional practice of not only disclosing exculpatory documents to defense, having received a report of investigation activities from SCUMO, which showed that Bob Express is not a designated non-financial business and profession, decided to drop counts 5 and 6 of the charge in the interest of justice and fair hearing, without any inducement or prompting of any sort from the defense, and in line with the mandate of the Special Task Force Against Naira Abuse. We attached the response from SCUMO. We also attached the charge showing counts 1 to 6. There was no amendment of charge. The dropping of counts 5 and 6 was done in court because the ex-convict elected to plead guilty to counts 1 and 4, which had to do with naira abuse. In any event, counts 5 and 6, which had to do with not rendering returns to SCUMO, showed that it was not the Bob Express which he used to trade, is not a designated non-financial business and profession. That's what informed our decision to drop counts 5 and 6 in court. An amendment of charges is not alien to practice, particularly sections 216 of ACJA 2015. It is also noteworthy that the alteration made by the prosecution did not contravene any provision of the extant policies of the Commission and its standard operating procedures. We have amended charges severally in court when the need arises. That steps taken by the prosecution in this proceeding, dropping in the proceedings, count 5 and 6, which is akin to amendment of the charges, can take place at any time before judgment, is not alien, as the Commission has, in numerous instances, had cause to amend, add, or subtract from the body of the counts of the charge preferred against defendants, and this will not be the last. We attach the records of proceedings of the court showing how we arranged the defendant in court. The Honorable, to show that the ex-convict there was no cohort between the prosecution and defense, the ex-convict even appealed the judgment of the court. If there was any interaction or any agreement, he would have gotten what he wanted and he couldn't have appealed. We also have the notice of appeal by the ex-convict attached to our documents. We also attached a copy of the charge, the record of proceedings, and the memo setting up the special task force that investigated the case of the ex-convict. So I want to state categorically that there was no form of financial inducement to any member of the commission, especially the prosecution team, in respect of this matter. All we did was we carried out our duty as regards to our core values of professionalism and the ethics that I took as a legal practitioner to prosecute and not persecute anybody. We are most grateful.
Are you done? Okay, can you tender the documents you have? Okay, dear colleagues, do you have anybody who wants to ask? The 2 count charges. Okay, can you explain more why the money laundering charges why it was dropped?
Okay, sir. As I said earlier, when we were analyzing the case file to prepare our charges, the purport of the charges in the first place was to charge for naira abuse and mutilation of naira currency. But then the defendant confessed that Bob Express, we attached his statement wherein he proffered this confession. Bob Express is not registered with SCUMO, Special Control Unit Against Money Laundering. And knowing that we can convict on a confessional statement, we went ahead to include counts 5 and 6 in the charge. But when he elected to plead guilty in court in the morning, and having at the back of our mind that we response from the Special Control Unit Against Money Laundering, saying that the Bob Express that we're charging for not rendering returns is not qualified to be a designated non-financial business and profession as provided under the Money Laundering Act.
Is it clear now? Okay. Do we have any other person? Okay. If we don't have any other person, I think EFCC, what they have is the main allegation against them is dropping of this charge, that they collected money to drop the money laundering charge, which she has said emphatically that they did not collect money. It's left for the committee to do our own investigation to know what they are saying, whether it's the fact or not. She has also said originally it was 6 count. They were charging for 6 counts, but she has explained why they had to drop the money laundering charge. So on that note, dear colleagues, the day is fast spent. I want one of us to move that we adjourn. Okay.
And
and the co-chair of the Joint Committee for the investigation of this disturbing allegation of corruption against the Efcc and other government agencies. I stand here today. My name is Michael Nzekwe, the Chief of Staff to the Executive Chairman. I stand to represent him. He sends in his sincere apologies for not being here due to the exigencies of duty that came calling, though he would have wished to be here. The letter of investigation into this very deep and disturbing allegation, we would like to just make this presentation on behalf of the Executive Chairman very quickly. Our attention was drawn to the viral video published by one Martins, Vincent Ute, aka Verydarkman VDM, wherein Idris Olarowaju, Okeneya, aka Bobrisky, and ex-convicts alleged that the officials of the commission received the sum of 15 million naira to drop money laundering counts in charge FRN versus Okuneye Idris Olarowaju. In the same video, the publisher, the Verydarkman, revealed that Bobrisky made this presentation to an undisclosed friend of his, whom he intended to receive a financial support from. Attached here is a copy of the charge we have marked as Enclosure 1. Given the gravity of the offense, which touches on our core value as a commission, it touches seriously on our core value, and we do not take kindly to the integrity of the commission, one of the best all over the world and in Africa, for our integrity to be touched. Given this value of integrity, courage, professionalism, and collaboration, the Executive Chairman promptly constituted a team to investigate the claim and equally issued a statement through his various social media accounts to that effect. Whilst investigation is still ongoing, the Executive Chairman received from this Honorable House an invitation directing his appearance and the concerned officers of the Commission before this Honorable Committee for an investigative hearing. Upon close scrutiny and analysis of that video that gave rise to this investigative hearing, the Commission observed the following: that the published and widely circulated video contained a private conversation between the ex-convict and a yet-to-be-identified individual who, in an attempt to obtain monetary benefit, alleged the compromises and the compromise of the officers of the Commission, the Nigerian Correctional Service, a private legal practitioner, Femi Falana, SAN, and a private and Fals, the bad guy. That in an attempt to induce and convince the yet-to-be-identified individual into parting with his money, the ex-convict alleged that the sum of 15 million naira was demanded by the officers of the Commission to drop the count of money laundering counts in counts 5 and 6 of the charge sheet, and that he could not transfer the said sum from his account because of the investigation, thereby inferring that the said account was frozen. That at the time he was demanding for this money and claimed his accounts were frozen or under investigation, the Commission never, at no time in the course of investigation, placed the account of the ex-convict under post-no debit. His account was never frozen throughout the period of investigation. Whereas the ex-convict mentioned the names of his friends who raised various sums of money and credited same to the account of his brother. The names of the officers of the Commission that allegedly collected the bribe were not disclosed by the ex-convicts. Also, the mode, the place, date and time of the delivery of the alleged bribe or to an account where it was paid was not disclosed by the ex-convicts. Arising from the above observation, the Commission wishes to state categorically as follows. In view of the prevalent nature of the currency, mutilation and abuse of the naira, which has been expressly criminalized by Section 21 of the CBN Act 2027, the Commission, in a bid to curb the said offences and in the discharge of its statutory duty, set up a special task force via a memo by the Executive Chairman to all its directorates. Now, attached here with is also a copy of the said memo marked as Enclosure 2. As a result of the setting up of this special task force and the vigorous sensitization, investigation and prosecution, a number of convictions were secured, which has significantly stemmed this dangerous tide of abuse of the naira, to which all Nigerians are witness today. It was in the course of carrying out its mandate that the Special Task Force of the Commission, Lagos Directorate, received intelligence which revealed 4 different videos of gross abuse of the naira notes perpetrated by the ex-convicts, which warranted his investigation and prosecution. That on the 3rd of April 2024, the ex-convicts, while undergoing investigation, in his extrajudicial statement, confessed clearly inter alia, Bob Express is not registered as SCUMO, Special Control Unit Against Money Laundering. I'm not aware. Hence the inclusion of count 5 and 6, due to his own confession that Bob Express is not registered. So the prosecutors had to now include all of this and then did a further check on that. Now, in the body of the charge, this was included wherein the defendant, now ex-convict, was alleged to have failed to submit to SCUMO a declaration of his activity, which is contrary to Section 6.1 of the Money Laundering Prevention and Prohibition Act 2022, and punishable under Section 19 of the same Act, in addition to the substantive offense of tampering with the naira note as contained in count 1 to 4. However, on the 5th of April 2024, notwithstanding the unequivocal confession of the ex-convict, admitting the essential ingredients in count 5 and 6 of the charge, and having indicated willingness to plead guilty to count 1 and 4 of the charge, the prosecution, in total fidelity and candor to his oath and strict adherence to professional practice of not disclosing documents to their defense, having received a report of the investigation and activities from SCUMO, which showed that Bob Express is not a designated non-financial business and profession, decided to drop counts 5 and 6 of the charge in the interest of justice and fair hearing, without any inducement or prompting of any sort from the defense, and in line with the memorandum of the the mandate of the Special Task Force Against Naira Abuse. We have this also attached here and marked as Annexure 3. That the Honorable House is invited to note that alteration, amendment, addition of charges is known to law. Very known to law. Particularly Section 216 of the Administration of Criminal Justice Act 2015. It's also noteworthy to note that it is also noteworthy here to note that the alteration made by the prosecution did not contravene any provision of the extant policies of the Commission, nor a standard operating procedure. That the steps taken by the prosecution in proceeding to drop count 5 and 6, which is akin to amendment of the charges, can take place at any time before judgment is not alien, as the Commission has in numerous instances caused charges to be amended. You can see our attachment as Enclosure 4. The Honorable House is urged to use this constitutional power to ensure that corruption and other vices are exposed, investigated, prosecuted, and also ensure that patriotic and dedicated officers are not blackmailed, demonized, and demoralized for faithfully serving and carrying out their lawful duties. That the Commission has been consistent in its advocacy, calling on all public with credible information on any alleged act of corruption involving any of its staff to come forward with evidence. This, the public is urged to do responsibly. Short of the ex-convicts, and other accusers openly naming the officers of the commission to whom they allege gave the bribe of 15 million naira in order to induce and influence the dropping of counts 5 and 6 of the charge bordering on money laundering. It is reasonable to infer that the ex-convict merely made up the story to convince the yet-to-be-identified person he was speaking with in order to obtain financial favor under the pretense by dropping the name of the commission. We wish to draw the attention of the Honorable House to the fact that the onus of proving this grievous allegation against officers of the commission rests squarely on the accusers in this case.
Thank you for watching. If you're new to this channel, consider subscribing so you won't miss out any of our latest video.